Good morning and welcome to our first day of our March oral arguments. I will call the first case, Williamson versus AAA of Michigan. Good morning. This is a 15-minute mini oral argument on the application. You may reserve time for rebuttal. We ask that you keep track of that if we don't use it up, and you may begin when you're ready.
Thank you, Madam Chief Justice. Lori McAllister and my colleague Aaron Sedmak on behalf of AAA of Michigan, who is acting as the servicing insurer for the Michigan Assigned Claims Plan. It is our honor to appear before the court today. We would ask to reserve 5 minutes. We are here seeking reversal of the decision of the Court of Appeals, which of course reversed the decision of the trial court dismissing the Assigned Claims Plan, AAA of Michigan, from the case. Our position, as we've stated in our briefs, is that MCL 500-3173A4 applies to misrepresentations that are part of the claim or in support of the claim whenever they may occur, whether it's pre-litigation, during litigation. The statute still applies to make the claimant ineligible to claim PIP benefits as part of their case. We have two principal reasons that we believe our position is legally correct. First of all, it's the language of the statute, which I'll review in more detail. And then secondly, we believe the case law and the precedent from the court supports the position that we advocate here today. Starting first with the statute itself. If you look at the statute itself, you have to have a written statement that is given in part in support of a claim for it, or in whole in support of a claim for benefits, submitted to the MAIPF or to its servicing insurer, that the statement contained false information, they knew that it contained false information, and that it was material to the claim. There's nothing in the statute that says at what point in the claim process that statement is given. It does not limit it to the pre-litigation world versus the time period when a case is in litigation.
Just a quick question. How do you distinguish between fraud and mistake? You know, it could just be in certain situations that a mistake was made. How do we distinguish between that?
Well, I think that sometimes that might be a question of fact. In this particular case, however, it's not a question of fact, because what we have here are signed attendant care statements and signed replacement care statements that were dated as if that care had been rendered in October, November, and December of 2019. We know for a fact that Mr. Williamson died in October of 2019. So this isn't a mistake case, Your Honor. This is clearly a situation where this was absolute fraud. In fact, in this particular case, and we show this in the documents that we've submitted, we didn't even know, the carrier didn't know that this claimant had even died. We didn't find that out from the plaintiff. We found it out because an adjuster was digging into the case and happened to Google his name and came across his obituary. So this isn't a situation where there was, oops, we just made a mistake by letting some documents go through. This is where they had signed and submitted by way of interrogatory answers saying, this is our claim. So
Ms.
this
McAllister,
is not a
can I ask you
mistake.
that? Because I'm struggling with whether or not, what would we how would we find that this claimant had made a claim for attendant care benefits from the date of death through the end of December of that year, right? Which is,
right.
They submitted, or the replacement attendant care forms covered the whole year. So I'm looking at, the complaint doesn't allege specifically
Right.
a claim or an assertion of the right to benefits, however we want to call this, for that period. The answers to the interrogatories don't specifically say that, right? They left blank. They didn't
They
say.
basically say
state
see
the
attached.
period. They say see attached,
Right.
right? I assume, maybe not, do you know if these interrogatories were submitted with a request for production of documents?
Yes, these
Okay,
were accompanying discovery responses that came in.
So they didn't answer the question, they didn't answer that question that said, here's the period of time that we're seeking benefits for. They said, see attached these forms. They denied seeking those benefits in the answer to the motion for summary. And the caregiver testified that she didn't provide these services after the gentleman died, right? I guess I'm struggling to see, especially because the notice of death had been filed and the daughter substituted in as the plaintiff before these answers were ever submitted. So, is it truly that it's just that phrase "see attached" that is the basis for that they are asserting a claim for attendant care benefits from October 24th through December 31st?
It's not only see attached, but it is in fact that when you say to someone in discovery, here are the documents that are the basis of my claim, and you give me signed documents that say, I provided attendant care services and I provided replacement services for these 2 months. The other party in discovery is intended to rely on those.
But you're saying submitting the form is what is substituting for I provided attendant care for those periods.
Right, because remember, under the court rules, a party has an ability, rather than writing out an interrogatory response, under the discovery rules, you're allowed to just say, see attached, rather than writing it out.
So if these were part of a document production,
Right.
were these the only documents turned over in response to the production for documents, or were these part of a larger document dump, for lack of a better word?
My understanding is it was part of a larger document production, but it was not a significant production because this really was the only issue in the case, was attendant care and replacement care services. That was the only no-fault benefit that I understood was that issue. But I didn't handle the case below,
Sure.
so I might be a little rusty on those facts.
So
Counsel-
even though I believe the defendant filed the notice of death, right? That was a filed document in the court record.
We filed it after we discovered it.
Sure, but and plaintiffs
Googling
were
it.
substituted in, so these answers come after that. They've denied that in response to the motion for summary. The
After we
caregiver
caught
denied
them.
providing those services in her deposition, and they didn't actually assert them by those words, by that date, in answer to the interrogatory or in the complaint. But it's the see attached is sufficient, you say?
It is sufficient.
Because it's responsive to the question, are you seeking these benefits?
Right, and under the court rules, we allow parties to say, you can, rather than writing out your responses, you can refer to documents in response. So I see no difference between saying, here's our interrogatory answer where we write out, we are seeking these damages, and see attached, here are the documents that are our damages. Unless we're going to write that provision out of the court rule, parties have to be able to rely on the documents that are produced to them as speaking for the parties in response to the requests that are given. So I acknowledge that they tried to correct this and say, oh, geez, you caught us. But the question isn't, do they try to correct the fraud? The question is, was a misstatement that was made and was it material to the claim? And that is met here. The statute doesn't talk about, well, if you get caught and you fix it, then you get to make a claim later. Maybe the legislature should consider something like that. But the statute itself doesn't have that kind of provision in it that would permit a party to say, you caught me, and therefore I'm going to change it. I'm going to withdraw part of my claim and no longer seek the benefits that even I admit you caught me on, and we're not seeking that claim.
And
Are you arguing that the service forms themselves are claims?
The attendant care forms,
Yep.
they are part of the claim, yes. They are part of the demand for payment. And under Griffin, this court has said that when you are looking at what is the claim for, what is a claim consists of demands for payment. Now, we do not contend that a claim and an action are the same thing, but we do contend that they are also not mutually exclusive. When a claim is filed for benefits, especially a no-fault claim, there's continuing care that is being given. In almost every no-fault claim in this state, there continues to be benefits that are incurred or damages that are incurred because there are continuing injuries that require treatment. All of that is part and parcel of a claim. So unless it's a closed benefit period, which we didn't have in this case because there were still things incurred after the filing of the complaint, it is still part and parcel of the claim, the demand for benefits that was being submitted. Under Griffin, that
Does the
fits
claimant
squarely
have to
within Griffin.
does the claimant have to reapply for benefits each time they incur a new expense?
No, which is why it's part of the claim. Once you file a no-fault claim, you can add in those additional expenses that you incur during the course of the litigation. If you wanted to file a new lawsuit,
That's
you
where I'm
could.
having difficulty, because that's why I asked you if the actual forms themselves are claims.
They
And I
are
thought-
part of the claim. Under the No-Fault Act, you have a series of injuries and you have a series of care that's incurred. You could consider each of them a claim, but they are also part of the no-fault claim. So in looking at the statute, they are part of the no-fault claim. And that's why we contend it is part of the claim that was brought before the court and litigated as part of this lawsuit. The lawsuit said, we are bringing a claim, and very generally spoke in terms of wanting attendant care benefits, replacement costs. That's what this claim was about that was before the court.
Would it have made a difference if the form had been submitted before Mr. Williamson passed, and it covered the entire year? So you got it in September, and it assumed services in October, November, and December. Would that have made a difference?
Yes, because then we would have said those are not yet incurred. And under the Act and under the case law, including the Nassar decision that this court rendered, those would not be incurred, and therefore they are not yet recoverable under the Act.
But would that be fraud?
Pardon me?
Would that have been a fraudulent submission, in your opinion?
In that situation, I don't think so, because I don't think that there would have been an intent to a knowing intent to recover those benefits in that situation. I do see that as distinguishable from what we had happen in this case.
What about if, you said attendant care was the main issue in this particular claim. What if there was also some medical benefits and other things, wrapped up in these, which, as you know, these cases can have many different kinds of bills.
Yes.
And the discovery related to all of that.
Yes.
And then there was, arguable fraud on this particular, the attendant care piece. How would that impact the rest of the case?
The way the statute is worded, it's very broad, and it basically says if it's part of the claim, the whole claim
The whole case goes away.
Yes. And I apologize, but I'm down to 1:20, so if it's okay with the court, I will step aside and save my 1:20 for rebuttal. Thank you.
Thanks.
Good morning. May it please the court, Kyle Kelly, on behalf of the appellee in this case, the estate of Charles Williamson. Our argument, our position here, is also based upon two main arguments: that the language of the statute dictates affirmation of the Court of Appeals decision, and also that precedent of this court dictates affirmation of this decision. This is a discovery violation. That's what it was. And the Court of Appeals got it right when they kept their decision and they kept their analysis of the case to the discovery realm under the court rules. I'm not going to rehash what Judge Garrett wrote in her opinion, but a discovery violation, as in this case, is not a claim, is not part of the claim in a 3173A4 context. And we know it's not part of the claim in a 7143 context because of the plain language of the statute. Your Honors asked us to focus on 3173A4, but if I can direct you very briefly to 3173A1, where the statute says, and I'm paraphrasing, the Michigan Assigned Claims Facility shall review a claim for personal protection insurance benefits under the plan and shall make an initial determination of eligibility. That's the claim. That's the claim in a 3173A context. It's the submission made to the MAIPF for eligibility, shall review a claim. If the MAIPF can't review it, it's not a claim under this section. Every other subsection of 3173 bolsters this idea. 3173A1 we discovered. A2, sub A, requires claims to be made on a form approved by the MAIPF. A3 speaks of the assignment of that claim to an insurer. It's all over the statute. It's even back in 3172. The claim is what the MAIPF does when it determines whether or not this person who has come to the assigned claims facility and says, I don't have insurance, I need coverage, and they fulfilled the criteria laid out in the 3172. The MAIPF has to then make a determination, is this person eligible for benefits? That is the claim. And it's not answers to interrogatories, because answers to interrogatories are not reviewed by the MAIPF, and they're not on MAIPF-approved forms. And that's not what gets a claim assigned to an insurer. If you just answer a discovery in a lawsuit, that doesn't get to the MAIPF.
But under the statute, or in this case, we're not talking about a claim specifically to the MIAPF, right? This portion of the statute is a claim assigned to the insurer, right?
Correct.
So is it your position that a claim, that that a claim ceases to exist once an action is filed?
Not a claim in the sense of the whole No-Fault Act, but a claim in 3173 is only the claim for eligibility. And eligibility can be ongoing. It is not just the very beginning, because a claim is made to the MIPF, it gets assigned to an insurer, the investigation continues. We've all seen cases, I'm sure, where a MAIPF claim is made, an insurer is assigned, and then new information comes to light, and it turns out, hey, there was insurance somewhere. So then that insurer gets substituted in, reimbursement is paid, etc. So that the ascertainment of eligibility for MACP benefits is an ongoing process. So
if it's ongoing, the statute talks specifically about a claim that contains or is supported by a fraudulent insurance act. How is not submitting those documents supportive? And what do we do about the fact that these claims can sort of be ongoing as far as getting the money because it's continuing care over a long period of time? So what do we do about that?
I'm sorry, which documents? The initial document, like the initial application, or attendant care?
When you're submitting for attendant care, let me ask, do you agree with the premise that in discovery, there are documents basically submitted saying, I'm still getting care, here's how much this is costing?
Yes.
Okay, so how are those not documents supporting the original claim for attendant care?
Because they're not supporting the question of eligibility under 3173A4.
So your interpretation is the legislature only meant to deal with initial eligibility and not anything after the fact?
Eligibility, I wouldn't call it initial eligibility because, it can be ongoing. Something could be discovered 10 months after the initial determination is made. And the statute, 3173A1, says initial determination. And then it gets sent off to an insurer, and they do EUOs, and they do whatever they're going to do to further run that down.
But what do we do about the no-fault amendments, which I think everyone would agree bolstered sort of the concerns about fraud? That was a big part of the discussion with the no-fault amendments, and they bolstered the fraud provision, and that just doesn't apply here.
Well, it applies. It changed it originally, so this is my memory, said statements made to the MAIPF period, and then it changed it to include or an assigned insurer. But the assigned insurer continues that analysis of whether this claim is even eligible for benefits. So when 73A4 speaks of fraud, that's what it means. It's in the eligibility claim for MIPF. And if fraud is committed there, if somebody submits an application to the MAPF and that contains fraudulent information, then I think the second sentence in A4 would be triggered to eradicate the entire claim.
So is it, I just want to try and understand, make sure I understand. Your position is that the word claim, as used in 3173, is distinct from what a claim means in any other provision of the No Fault Act?
Yes, Your Honor, because we have to read the word claim contextually. That's what this court did in Griffin, when it considered what claim meant in a 3114 context.
Is 3173 part of the No Fault Act?
Yes, but claim is all over the place.
Right, so why would we ascribe a different meaning to one section as opposed to another?
Because frankly,
Without the legislature directing that, as used in this section, claim means X.
one, because this court already has in Griffin, when it looked at 3114, and it said that to make a claim under 3114 is to make that claim to the highest priority insurer. And you specifically use the word claim in the 3114 context. I'm paraphrasing, but it did use the word context. So in a 3173 context, we're talking about the application for initial eligibility for benefits. In other places of the 3112, for example, it gives medical providers a direct claim and cause of action. So a 3112 claim that a medical provider can make directly to an insurer cannot mean the exact same thing as 3173 A1, 2, 3, or 4 that talks about reviewing, a claim shall be reviewed by the MAIPF, must be on an MAIPF form, and it must be insured. One of your honors asked a question, I'm forgetting who it was, that if a new application must be made every single time a benefit is incurred. No, of course not, because a claim can mean the small little slice of benefits, and it does in certain sections. When a medical provider makes a claim directly to an insurance company for a surgery he or she performed, then that can be a claim as used in that context. But in 3173, in a very, very different context, it can't mean the exact same thing because there's no form, there's no review, etc. Does that answer your question, Justice? Mm-hmm. So by looking at what the legislature wrote, not only does every other subsection of 3173 specifically deal with that initial claim to the MAIPF, and everything makes sense in that context and that context only, they specifically differentiate between claim or suit. I believe that's in sub A3, claim or suit, because they're different. A claim is not a suit, and as this court observed in Griffin, filing an insurance claim is not the same as filing a lawsuit. And discovery violations in lawsuits have their own remedies. The court is empowered to impose any number of sanctions or corrective measures for a discovery violation. It can be money sanctions, or striking of evidence or claims completely, or the wholesale dismissal of a lawsuit. That's the way to deal with the discovery violation, to impose a discovery sanction. Because the business end of what AAA is proposing here is frankly horrifying. A4 says any person, not the claimant, any person who submits false information can completely obliterate a person's no-fault claim. And I gave some examples in my brief, but again, looking back to 3112 for a second, a doctor files their own lawsuit to collect PIP benefits directly against an insurer. Individual claimant not involved in any way. That doctor commits a discovery violation. Let's say they claim there were a visit on a certain day that there was no visit. That person, that discovery violation, under this analysis that AAA is proposing, completely destroys that injured person's PIP claim. They are now no longer eligible for PIP benefits because a person submitted false information. That cannot possibly be considered the way that a remedial act such as the no-fault act should work.
Counsel, how, I mean, what I'm hearing is, so potential discovery violation, and then, I mean, it sounds like disagreement whether there was fraud or not. Based on your briefing, sounds like a mistake. How should this case have proceeded? Obviously, it was decided on a motion for summary. How should, obviously, the Court of Appeals, I understand, disagreed with the trial court, but I'm just curious when there's, it does seem difficult here, sitting here, that I'm hearing a difference, obviously, in opinion whether there was fraud or not, obviously. That sounds like a question of fact to me, and so what would be the remedy on that?
So the remedy would be up to the trial court, and that is an issue that is still preserved here today. The Court of Appeals didn't reach it, but it was preserved. Their argument was there was no fraud, there was no intent, et cetera. So if the court wants to go down that road, that issue has been preserved. What should the trial court have done? I was not trial counsel either. There's a whole list of factors, and as to how egregious a discovery violation is. Is it the first time? Was there a violation of an order, et cetera? The trial court had remedies. Maybe it should have given the plaintiff a chance to amend and correct its submission. Maybe it should have levied some kind of sanction. Maybe it should have struck the offending party as a witness. There are any number of things. And also one thing I want to throw in here, the attendant care forms that were for after Mr. Williamson died were not signed by Mr. Williamson or either of the PRs. They were signed by a caregiver who's not a PR, who's not a claimant in this case. The interrogatory answers obviously were. But the actual claim submissions were not signed by the plaintiff in this case.
I'm sorry, what does that matter?
It matters because
they were submitted, right?
They were submitted as part of the interrogatories. They were never submitted directly to the no-fault.
But isn't there an obligation to review that?
Yes, I think there's an obligation. Well, there's an obligation that your answer should be truthful. And just to get back to the point that was made earlier, the answer C attached, frankly, was accurate. She attached, her attorney attached, everything, every form. And the reason given in the trial court was the attorney was attaching every single thing he had in his file. Here's all of it. The offending claim forms were not part of the claim file. They were never relied upon by the no-fault insurer. They were never paid. The no-fault insurer didn't even know about them.
Is there any requirement of reliance in the statute? We've been banding about the term fraud, but I don't see any reliance requirement.
No, but it does say material, Justice. It says that the false information must be material. And if there is a claim that was never submitted directly to the insurance company and was never part of their claim file and was never considered or adjusted for payment, I don't think it's material.
What are you calling a claim in that instance? You just said that this is a claim, right? This is what I'm struggling with. A claim is used multiple times. It's not defined separately. And if it has to be material to the claim, maybe the forms themselves aren't claimed, but in submitting those and responding to the interrogatories, is your client not claiming a right to those benefits under the No-Fault Act?
I don't think in a discovery response, no, because in a discovery response, you're not going to convince the insurer to provide proof to the insurer. You're providing proof to the trier of fact, the judge or the jury in the case. So no, I don't think that's a demand for payment to the insurer. I think that's, as Judge Garrett recognized in the Court of Appeals, that is a portion or a part of the litigation process where you're submitting your evidence. And we, in Michigan, favor broad discovery. So when the attorney gave everything they had in their file, here's everything I got, here's my entire file. And there were some forms in here that had been filled out in advance, and they ended up being inaccurate. So if I have 10 seconds.
Counsel, I just have one last question.
Sure.
The thing I've been struggling with is why would the legislature want to give a free pass to false information as long as it occurs in connection with a lawsuit over the claim and not the claim itself prior to litigation? Why would the legislature say the false information during litigation is not a big deal to us, you know, you go in front of the court and provide false information, no big deal. But if you do it as part of the process before litigation is initiated, it's fatal.
I don't think they did, because there are going to be remedies available outside of 73 or 3173A4. Fraudulent claims can be denied. That's the Shelton case. The insurance code, 4511, allows, makes insurance fraud a felony with restitution available. The insurer can receive attorney fees for defending fraudulent claims under 3148, and there's common law remedies too. And on top of that, second part of my answer, Justice, is the rest of the No Fault Act does not include a general fraud provision. And so the legislature has deliberately decided that we're not going to address that for the ongoing submission of claims. The only place it's mentioned is in the assigned claims facility, and as I've argued, the context of that is in determining eligibility.
I've got one question. I've been trying to ask it since the light went off. It goes back to your very first statements when you took the podium. It's been a long time since I've been a trial judge, but you called this a discovery violation.
Yes, sir.
My understanding of a discovery violation is the court orders the deposition of a litigant, they don't show up. They violated the court order, that's a discovery violation. Interrogatories were served, there was no answer given. That's a discovery violation. But answers given that are false, to me, is something much larger than a discovery violation. It's sanctionable action beyond discovery. It is a litigation sanction. Why should we accept that this false statement is a mere discovery violation?
Because it was given in answer to a discovery request. And
That's circular.
I'm sorry?
That's circular.
I don't think it's circular, because I also don't think it disagrees with what you just said a second ago, that it deserves a higher sanction. It can. A discovery violation can be sanctioned all the way up to a wholesale dismissal of the case.
Okay.
So if it is
You
a
keep calling it a
higher...
discovery violation.
I'm sorry?
You call it a discovery violation.
Yes,
I
sir.
call it a false statement made when there's an obligation, I won't say under oath, but when there's an obligation for a truthful response.
Fair, Justice, but I think that the way of punishing that would still fall under the discovery court rules.
But we have a statute here.
I'm sorry?
We have the Fraudulent Insurance Act, which might take it outside this scope, but I appreciate your response.
Thank you.
Counsel, how do you respond to the question as it pertains to that this could have a real far-reaching impact? The example that was given with the physician that loses his claim because he got a issue wrong as it pertained to when an appointment was supposed to be scheduled. How do we balance all this? That's my concern. The balance between making a mistake and losing everything and this case. Everything's a matter of degree, so explain to
Understood.
me how we should proceed with or without that concern, that a person files something incorrectly, does something wrong, misses a date, misses something, makes a factual, inaccurate statement. Is that going to impact upon those folks? And could this turn into a sense of gamesmanship, where basically you just ask a series of questions and someone misses that question or gets it wrong or says something inaccurate? I know it's a lot there.
It is, and so if I miss part of it, please make sure that I follow up. But first of all, it is not uncommon in the No Fault Act to make the fate of the providers follow the fate of the claimants. So for example, if you have an accident involving an uninsured motorist who should have had insurance but didn't, if there is a claim brought by the uninsured motorist in that situation, they are not eligible for PIP benefits. If there is a provider that tries to then make a claim against an insurer or against the MACP, that provider is out of luck too, because they have treated someone who is not eligible for coverage under the No Fault Act. So the legislature in that situation, as well as others, has routinely said the fate of the providers is tied to whether or not they are treating a person who is eligible for coverage under the No-Fault
I
Act.
think Justice
And this is
Bernstein's,
no different.
right here. I think
I'm
Justice
sorry.
Bernstein's question is in response to brother counsel indicating that, giving the example that a provider could
Yes.
fraudulently file, for services.
Yes.
And that if they do so under your reading of the statute, then the plaintiff's claim is out. What is your response to that?
My response to that is it doesn't go the other way around. If the claimant, the injured person, is the one that commits fraud, the provider's claim is derivative in nature and tied to whether or not the claimant is an injured person. If, however, it's the provider who makes the fraud, that provider is out of luck, but I don't think that that makes the claimant the injured person an ineligible person under the Act.
Where do you see
they are
that-
not
Where do you
derivative
see
in
that
nature.
distinction in 3173?
That is not in 3173. I think you have to look at 3173A and 3112, because 3112 is what ties, which is what tells you what providers have standing to do.
But that's
Providers
only if a
have
provider
standing.
has filed suit, right? What about a circumstance, and not to belabor this, but let's say the plaintiff is saying, I'm seeking medical benefits from day 1 to day 30.
Yes.
And in response to discovery, I'm submitting all the medical records from this provider relative to that treatment.
Yes.
And the medical provider fraudulently says, I provided services from day 31 to 60. Is...
In a separate action?
No, in the same action. And the statute says a person who submits something fraudulent relative to the claim. If the plaintiff has said, I'm only seeking benefits 1 through 30, but their interrogatories say, see attached, and it has days 1 through 60.
Then I think that they have
whole thing's
included
gone.
those, the whole thing's gone in that situation.
For a false or a fraudulent representation,
A false
even though
statement
their
to the court.
claim that they're representing in the lawsuit is day 1 through 30.
Unless they've made a statement that in their interrogatories that say, we are also providing records that have been provided to us by the provider. We are making a claim just for days 1 through 30. Then I don't think they've made a false statement. But if they just say, and
See
get
attached.
lazy and say, see attached, then
So
that's the difference.
Lazy is equating with being fraudulent?
Lazy is equated with, well, I don't know that I would call it lazy because I don't like to think of myself as lazy, but I do take advantage of the court rule from time to time that permits me to attach rather than.
Be held to those answers.
Right.
Okay.
So I don't think it's lazy. And in terms of gamesmanship, for your final part of your question, Justice Bernstein, I've been practicing law for 38 years, and I can tell you that there's always going to be gamesmanship in the system from the defense bar and from the plaintiff's bar, and we can never eliminate that from the system. But what we can ask is that our lawyers comply with their ethical obligations. We can expect them to comply with the court rules, and we can expect them to know what the rules are and to know that if they're submitting things that are false statements to the court, that they have to bear the burden of doing that, rather than asking on a case-by-case basis that we turn the definition of what constitutes an insurance claim on its head by saying, well, it's only things that are pre-litigation, because that does not comport with this court's precedent in Griffin. It doesn't comport with insurance industry custom as noted in Griffin, and it certainly is not consistent with the plain language of the statute.
I just want to follow up on something from Justice Kavanaugh. Are all discovery responses statements made part of or in support of the claim?
If they are relevant to the case, they are.
So that's the answer is no, you tell me. Either they are or they aren't. Are all
They
discovery
are.
responses made in support of a claim?
They are.
Really?
Well, I suppose that there could be situations where you are asking irrelevant things so that they would not be technically in part of or in support of the claim. So for example, I might ask
Okay,
you
I get it,
something
I
that
get
is
it.
not admissible.
I understand what you're saying.
Okay.
How do we write that in an opinion?
I think that you can write that in an opinion by saying, you use the words of the statute, that it's part of or in support of a claim, and then to the extent that somebody wants to make an argument down the road that, hey, this wasn't in support of my claim, then they are free to argue that in a particular case. This case, it's clear, I submit, because
When I
this
hear
is a
about this
case about...
You've heard that 100 times before. You've been here enough to know. That's why I asked, how do we write this opinion?
I have been here a time or two, I understand. But
Counsel-
this goes to the heart of the case, attendant
Just for
care.
clarification, if you were to prevail today, wouldn't we just be remanding to the Court of Appeals so it could address materiality and so it could address the intent arguments? Because that court didn't address those arguments, so wouldn't the
I
plaintiff
don't
be...
think, they may argue that that's what they would like, but I would argue that you do not need to do that. The scienter, as defined by the courts, is you just need to have, for knowing, all you need to have is that you've read the document, and these interrogatory, you're held to be accountable for what you sign. Just like for a contract, you're held to be accountable
I
for
get
what
that
you
you have
sign.
arguments to make. My only point is that don't they have a right to have an appellate ruling on those arguments? Because the Court of Appeals specifically said in its opinion that I think that it was not going to rule on those issues, right? I mean,
It did, Your
aren't we
Honor.
only here to determine whether the false statement bar applies to litigation, not just in the pre-litigation setting?
Well, I understand that position, and I just don't like it.
I mean, that's fine, I was been trying to understand sort of why we're talking about things like materiality and intent,
Right.
when the parties have arguments to make and maybe presented those to the Court of Appeals, and the Court of Appeals declined to rule on them.
They
So I
did
think the
decline,
simplest
I
thing for us
understand.
to do, if we were to agree with your position, would be to send it back so it could address those arguments.
I agree with you that the appellate courts have not dealt with those issues.
Thank you both. The case will be submitted.
Thank you, Your Honor.